All rise.
Yes.
I'm afraid I stand up because my client is obviously concerned about the issue that has arisen in relation to the government's response to the Ahmed Ali decision.
Yes.
And I have taken instructions over lunch, and I have been asked to seek your lordship's permission to put in a short note dealing with that issue. It didn't seem right to leave it as it stood at the end of the hearing just before the short adjournment. I understand from Lord Pannick, who I did manage to speak to before he left, that he has no objection. Mr. Gill equally has told me he has no objection. I think Mr. Fordham also has no objection, so that is my request to the court.
So will they be shown copies of the note? They won't have seen it yet, of course.
No. Indeed, it hasn't been produced. No. But of course they will, and of course we could have no possible objection to them responding if they thought it appropriate to do so.
How soon will it be available?
Would within 7 days be acceptable?
I think so, yes. I was thinking of 14, but 7 days would be fine if you can do that.
Well, I'm very grateful.
Thank you very much. Yes, Mr. Ford.
My lords, good afternoon. I'm going to start by taking stock of where we are in the light of what's happened in the other appeals. There are a number of absences now, I think all of them authorised. There is one presence, which is I need to introduce Catherine Casserly, who is here on behalf of the Commission, and they have put in a written submission. I don't think there is any permission for them to intervene orally, but she's present in court, and I hope that is not inappropriate.
Well, the intervention was asked on the basis that it would be in writing, but you would be available for questions, I think, if there were any to be put.
My lord,
so
yes.
We're very grateful to you being present. Thank you very much.
There we are, my lords. She's here for cross-examination, should it be appropriate. Now, where are we? If you've got the core volume for this appeal, AM number 2,
yes,
you will have seen from the statement of facts and issues, it's paragraph 7 on page 3, that there was the overlap point, including its Article 8 component, in which I have a held over reply submission. Page 3.
yes,
paragraph 7, 1. But I'm going to proceed, of course, on the basis that Ahmed Ali was right all along. And I need to bring to your attention that the consequence of that standing alone is that there was an error of law in the determination that has given rise to this appeal. That's in the appendix at page 30, where the immigration judge follows AM in preference to Ahmed Ali at paragraph 16.
yes.
And therefore, on the grounds that all we had was third-party support, though all the other requirements were met, see paragraph 18, we failed.
Yes.
So that's the position in relation to that issue. Now, the Court of Appeal, in the judgment of Lord Justice Maurice Kay, recorded the fact that the adequacy of third-party support wasn't a problem. It's the end of paragraph 1, you've got it at page 6. I understand we've had some discussion belatedly as to where we now are.
So just to catch that up, that's end of paragraph 1
Yes,
on
it's
page
the end
6.
of paragraph 1.
Yeah.
And the point that has been raised on behalf of the ECO was as to whether they would want, in fact, to probe further the question of adequacy of third-party support in circumstances where, in fact, the immigration judge had simply excluded it wrongly as a matter of law. I think I need to tell the court that the current position is that the ECO is considering whether, in fact, they would wish to continue to insist on a remittal. My lords will appreciate that if they wouldn't, then from the point of view of our client, not only does the appeal succeed, but entry clearance will be granted, and granted without the need for a further hearing. I don't know whether we're in a position to have an update in relation to the ECO's position, but I thought it right to explain to the court at the outset what the practicalities are. It doesn't change the fact that I have important legal points to make, and as things stand, the Court of Appeal's judgment will stand to exclude many others who have disabilities and are unable to work and aren't able to put forward convincing third-party support. But you'll appreciate I stand here on behalf of my client, and it's right, therefore, that I raise the practical positions.
Well, Ms. Kasfrisk is indicating she has a response to make.
Well, I'm afraid only this, my lord. We appreciate the position, as Mr. Fordham has put it. We've only just become aware of that. That's no criticism at all. But we're grateful for the indication, and I wonder if, therefore, I might have a short moment to seek to take instructions, because obviously we wouldn't wish to burden the court needlessly with a lot of interesting arguments about Article 14 if, in fact, the disposal of this appeal, so far as the appellant is concerned, could be dealt with in a different way, if that were convenient to the court.
Well, we may have to take this in stages, but I think it would be helpful if we had some instruction, or you got instructions and could tell us what your current position is, and then we'll see whether Mr. Fordham thinks there's something else that he wants to address us on. So shall we withdraw for a moment, and we can be told when...
I wonder if, just in fairness to my learned friend, I ought to make clear two follow-up points to this. The first is that I would be submitting that having discharged my duty to my client in relation to the practicalities of the matter, we of course are in your hands as to whether you would wish to deal with this point of law.
Yes, well, we appreciate that point.
That's the first thing to be aware of. And secondly, I would, in any event, be urging the court to record the doubt which arises as to the Court of Appeal's analysis, but albeit that on that hypothesis it wouldn't have been necessary to resolve it. Because
it's for that reason I said we should take this in stages. I think we need to know where Ms. Kasfrisk stands on the facts of the case, and we'll take it on from there.
We're great.
Thank you very much.
Aggregate or separate out exemptions. Way better. Too much. Too much. Just seems too clever. As to the
which they need to move before they can satisfy.
The problem is, as I understand it, thank you very much. I'll let you.
All right.
Yes.
Yes, I'm instructed that I can say that we accept that as a matter of fact there will be sufficient third-party support available so that on the construction of the rules that your lordships have suggested today is the correct construction, the consequence would be that this appeal would be allowed with no need for further remission to the tribunal. I should make it clear that, of course, we still maintain that on the Article 14 issue, the Court of Appeal's judgment was correct, and it's perhaps important just to make that clear. Should there be an amendment to the rules in the future to preclude third-party support? Now, I stress I have no instructions at this stage about that issue, but I just wanted it to be made clear that our position is, as I've said, that the Court of Appeal was right in principle. And I would also add, respectfully, that it would not seem to us appropriate for the Court to make any comment as to there being doubts about the Court of Appeal's judgment, which I think Mr. Fordham would like you to do, if the point doesn't go ahead and it isn't argued before
So
you.
just simply record the point was not argued.
Yes, precisely. So that's where we are at, my lords.
Thank you. Mr. Fordham.
Well, my lord, just two things from us. Firstly, providing it is recorded that there was a challenge to the Court of Appeal, and of course there are two aspects to it. One relates to third-party support, Article 14, but the other relates to the self-sufficiency.
Yes, your wider submission, I'm sure we appreciate, is that if you're disabled, whatever precisely that means, you don't even have to satisfy a requirement that you shouldn't be a burden on public funds.
That's right, and that would not have needed to be argued in circumstances where the appellant has won and will get entry clearance. I'm not going to say any more in relation to that. I just remind the court, secondly, that I will need in any event to make my brief we will recall that was carried over because it was more convenient.
On the other cases, yeah.
On the other cases, but I will be able to do that very, very good.
Now, sorry, just remind me why you have to do that now.
He didn't reply.
No, I appreciate the reply, but what, I'm sorry, but how can it affect one of your cases?
The Article 8 submission, I don't want to risk a Lord Panic win. If the court were going to say that the rule could be amended to exclude third-party support, and that was a point that I had argued in opening on behalf of my other clients, I do have a reply submission to make as to why that has been shown now to be wholly unsustainable.
I think you should proceed.
So we return to effectively to the other appeal.
I think you should switch on your microphones.
I'm so sorry. I do apologise. I hope you've heard
I
me.
don't believe those microphones have the
we can-
faintest
we can hear you
impact. Yeah,
perfectly
they-
well.
It wasn't for our benefit, but for your audience
Well, no,
downstairs.
no, but I think that they carry the sound downstairs. So I personally would be obliged if you would not only turn it on, but remember that it doesn't have any effect here at all, and speak up.
Well, I remember vividly the complaint on behalf of the press in the first appeal we had in this new Supreme Court about them not being able to hear. Article 8, my lords. Ms Carr's Frisk began her submissions on the rules by emphasising strongly two things. Firstly, the legitimate concern in protecting the public purse under these various rules. And secondly, the legitimate concern in relation to risks as regards reliability and verification. And in reply, firstly, we fully accept the legitimacy of both of those concerns. The protection of the public purse and reliability and verification. That's the first point. Secondly, the premise for whether or not third-party support can be excluded, the premise is that by reference to third-party support, the couple, if one's looking at 281, will be able to demonstrate under the rule that there will be adequate accommodation and there will be maintenance and it will be without recourse to public funds. And that's the only basis on which one reaches the question of allowing or excluding third-party support. That premise, that necessary premise, the task that we have to meet in any event, clearly meets both of the concerns, both of the legitimate aims. The public purse is protected because you have shown that there will be no recourse to public funds. Reliability and verification have been dealt with because a decision maker has been satisfied on that score.
By looking at what? By looking at the potential for third-party support?
By looking at all the evidence that is put forward in order to show that there'll be accommodation and maintenance without recourse to public funds. Because if you can't show that, you're going to fail. And one can test it in this way. If the rule were now amended to include for the couple what is included for the artist, that is to say the phrase from their own resources, then we submit that it is very clear by reference to both legitimate aims relied on that that would be disproportionate. That would be a disproportionate restriction. Why is it convincingly established to be necessary to say that yes, you can show accommodation and maintenance without recourse to public funds because of the uncle, for example? The clearest evidence to satisfy that that is so. But we're going to impose a further restriction to require that that has come from you. And the consequence, because these are necessarily Article 8 cases, we're
Well,
talking about...
I mean, you say they're necessarily Article 8 cases. I mean, I I thought we'd been through this, and certainly in regard to 317. I mean,
Well, I'm focusing my submission on 281.
I thought this was a wide submission that went to all of them.
Well, I'm focusing this reply submission. I'll come to the other rules in a moment.
Your clients are 281 people.
Yes, they are.
Yeah.
There is no doubt that when a spouse is seeking to join their spouse present and settled in the United Kingdom, that there is an interference with Article 8 in refusing entry clearance.
What about if they can, as I think on the facts it may well be in your two cases was found below, they could reunite abroad?
That's a point that goes to justification. It doesn't stop these being Article 8 cases. That's a point that whether you can replicate your family life abroad is always a feature which goes to whether you can justify the interference. But
where's the authority for that?
My Lord, it's in one of the Court of Appeal cases, and it's a judgment of Lord Justice Sedley. I will find it for my Lord.
Does that court, is a clear Strasbourg jurisprudence to that effect? I hadn't thought there was.
Is it under the proportionality chapter that it comes in?
It certainly, yes, it comes in.
There's a well-established progress of thought as one
Yes.
goes through the various levels, but it comes under proportionality.
It certainly comes under proportionality. That is my submission, that one has an interference and the ability to replicate the family life abroad is a relevant feature ever since Abdulaziz in relation to whether you can justify the interference. But my lords need to recall and keep clearly in mind the framework for all of this. The framework for all of this is a rule that is saying you qualify for union here, provided that you are not a drain on the public purse. And what would need to be justified is why it's necessary to say that you're not a drain on the public purse.
But Ms. Ford, just suppose that it costs more money, it is administratively more cumbersome to have to deal with third-party funding. Just assume that, because it seems to me by no means inconceivable that that could be so. I mean, you know, there it is. There are reasons, apart merely from having to satisfy public funding, you have to do it in a way that's reasonably economical.
Well, my response to that
Yep.
is, first of all, that it is not the aim or concern that was being advanced by the Secretary of State.
That's
is
not
point
right.
one.
I don't think that's so.
Well,
It occurred to me, and I say following the same line of thought, that you were putting the cart before the horse, really, by assuming that all the work had been done, which, according to the argument we heard this morning, the Secretary of State was trying to not have to undertake.
Well,
administratively demanding, to some extent very difficult to reach decisions on, and so on and so forth.
so be it. My second response to that suggestion is that the administrative cost, the incremental administrative cost, if there be some,
Is what?
if there be an incremental administrative cost, let's assume that there is, of the entry clearance officer who already has to look at the employer, who already has to look at the person who's providing the accommodation, or going to give the loan, or going to provide the gift, or is going to enter into the contract, or the deed. All the list of examples that Ms. Carrs-Frisk accepts are permissible consistently with what was her interpretation, and on this hypothesis would be the new rule. The incremental additional administrative cost of looking at the uncle or the third party who is part of the applicant's case for satisfying that the public purse is protected cannot begin to bear the weight of justifying the refusal on this ground of family union. And remember, the ground is, yes, you can show no recourse to the public purse, but no, it's not from your own resources as a couple. It's a simple submission. We submit that it is a compelling submission. The fallback, of course, would be that one would anxiously scrutinise in individual cases whether it's compatible or incompatible to require of a particular couple that they provide the resources themselves. Now, if anything, that's going to involve more administrative costs, but that's Plan B. Plan A is straightforward, that this simply could not be objectively justified. I have already accepted and repeat that it would be another matter if the Secretary of State chose, for example, to permit, under the rules, undertakings from third parties in order to assist with reliability and verification. And that is an obvious option which illustrates the importance of proportionality. When you're saying to yourself as the state, how do we protect ourselves from a drain on public funds? Do we really need to do more than ensure that the decision maker, and it will need to be proven to their satisfaction. If there's doubt, they'll say no. Do we need to do more than to insist on satisfaction that there will be no recourse to public funds? It is, we submit, disproportionate in an area which necessarily engages Article 8 to do so. I simply extend the argument one further step in case it is of assistance. One needs to recall that the premise for all of this is not just no recourse to public funds having been demonstrated from third-party sources. It is also that we're talking about a genuine marriage and an intention to live permanently together in the United Kingdom. I hope it's right for me simply to take this small step, but it is very plain that the same argument must hold in 297, because the premise for 297 is that one has the child who needs to be here with their parent or other relative because their other parent is dead, or this is the one with sole responsibility, or there are serious and compelling family and other considerations. And again, it is quite impossible objectively to justify, whether it's in the rules or not, the conclusion that says, yes, you can demonstrate that you can come here to be with the relative that you need to be with without any recourse to public funds, but nevertheless you've got to stay where you are, overseas, because you, or more particularly your parent here, will need to be relying on someone else in order to be able to come up with the money that's needed to protect public funds. My Lords, it's a short point, but we submit respectfully that it is a compelling point. I have to apologise to the Court that it would take me a moment to return to the question that I was very fairly asked, and I do apologise,
yes,
as to replicability of the marriage as going to proportionality and justification. If you just give me 30 seconds in case I'm able to do it immediately. Look, I'm afraid to say, I think it's going to need to be something that I myself ask for the indulgence of being permitted to put in a page if that would be...
Well, I think it would be helpful, yes.
Unless there is anything else.
On a page, I think you've got with an opportunity to respond,
Yes,
because I actually think it's quite an interesting, I mean, how presently important, I don't know, but I'd like to know the answer.
Yes. Models, unless there are any further questions for us, those are the submissions that I wanted to make in reply on that point.
Thank you very much indeed. Thank you. Ms. Casserly, we don't need to trouble you. Thank you very much for coming. And we're extremely grateful to Council for their assistance in all these cases. Their Lordships will take time to consider their decision, although in the case of AM2, the decision is already conceded, I think, but so far as the others are concerned, we'll take time. Thank you very much.